When a company sells a high value asset, does it automatically trigger shareholder approval? And does a distress sale change the legal position? Hello everyone, today I would like to discuss a recent judgment delivered by National Company Law Appellate Tribunal in the matter of Madhukar Anantrao Pathak versus MPTA Limited, which provides an important clarity on the concept of asset versus undertaking under Section 180 of the Companies Act 2013. As per Section 180 subsection 1 clause A of the Companies Act 2013, the board can sell or dispose of a company's undertaking or substantial part of it only after getting shareholder approval. Let's move towards the background of the case. In this case, the company had sold a property known as Sakar Bungalow. Minority shareholder raised an objection to the transaction on the grounds that the value of the property exceeded 20% of the net worth, and therefore shareholder approval by way of a special resolution under Section 180 subsection 1 clause A was required. However, the company contended that a property was not a part of any business activity and it was a non-operational asset, and hence Section 180 was not applicable. The key issue before the tribunal was whether sale of an high-value asset amounts to a sale of an undertaking. The tribunal clarified that an undertaking refers to a business unit that is generating revenue and integral to company's operation. An asset, on the other hand, is a standalone property or investment not necessarily linked to business activity. The tribunal highlighted that 20% threshold is not the main concern. Firstly, it must be determined whether the asset qualifies as an undertaking or not. Since the property in this case was not generating any revenue and not a part of a core business operation, it was held to be an asset and not an undertaking, and therefore Section 180 was not applicable. Another important argument raised was that property was sold at a lower value, possibly under a financial pressure. In this regard, the tribunal also clarified that valuation, whether high or a low, does not determine applicability of Section 180. A distress sale, that is a sale under a financial pressure, does not change the nature of the asset. Such factor may be relevant for examining fairness or a potential dispute, but that does not affect the classification of asset versus undertaking. Conclusion. This judgment reinforces the following important principle. The functional test is more important than the quantitative threshold. Section 180 applies only to sale of an undertaking, not individual assets. High-value transactions alone do not trigger shareholder approval. Valuation and distress condition are relevant for fairness but not for classification. However, the appeal has been filed with the Supreme Court of India by the appellant shareholder and is currently pending. As per the publicly available information, the appeal is under the defect stage and has not yet been admitted by the apex court. Thank you.